When you're diagnosed with melanoma, you're confronted with a number of different choices and options. And you also may have some doctors who are not very familiar with melanoma, who may tell you these very incorrect phrases such as go and get your affairs in order, or tell you that you only have a short period of time to survive, when in fact you may not. And so it's important that you make some really informed choices and decisions about what you can do about your future moving forward. So today we're going to be joined by Adam Tayler, who's Special Counsel with Turner Freeman Lawyers, and they've assisted us in hosting the event today. And Adam will share with us some really important topics regarding how to be prepared with your own affairs to enable you and your carer and your family to be able to make some choices about you as you move forward. And it may be that you don't need these things, but it's important that we know what tools and what resources are available to us to make our journey as easy and comfortable as possible for ourselves and our family. So Adam, if I could welcome you up.
Thanks, Tilly. It's always great to talk at events like this. Our firm has had a long association with the MPA, and we're very proud of the support that we provide to this association, which is doing just fantastic work. I first had contact with the MPA through one of Joe's sessions at the Danger Sun overhead, and I was blown away by what this disease is all about. So I'm happy to be here today, and hopefully some of the things that I can identify will help you moving forward. There's lots of things to think about when you're diagnosed with any serious illness, or for that matter when you suffer a very serious injury. It will, as you know, impact on every aspect of your life. Legal issues are probably something that you just don't want to think about, and you might think that's not important. What's important now is my health and getting better and undertaking treatment, and that's true. But if you let the legal issues slide, they can become more murky and more complicated than what they originally could have been. So what I'm going to try and do today is just give you a few things to think about, and these are, as Tilly mentioned, these are not necessarily things that you automatically need to do on diagnosis, but they are things to keep in the back of your mind. Depending on the age at diagnosis, obviously things like workplace rights and issues arising at work and what sort of entitlements you might have at work can be top of mind as well. There are many good employers out there who will support people and will do the right thing. There are national standards for the type of leave and those sorts of things that you should have access to. It does depend on your particular workplace and whether there are written contracts of employment in place, enterprise agreements, or whether you're an award-based employee. So your rights can differ depending on how your employment is set up. But there are certainly protections out there for you under the legislation. An employer is not able to discriminate against you as a general concept just because you've suffered an illness or an injury, whether it's work-related or not. The employer has, you have certain protections in that regard. If you can't work because of an illness, then you're entitled to be off work, be that either paid, so if you have sick leave, then you can access that, or unpaid. And your employment, as a general rule, can't be terminated because you just don't turn up to work because of an injury or illness. There has to be a period of time that passes. Again, it can depend on the status of your employment, so whether you're casual, part-time, full-time. But looking at a normal full-time person or a permanent part-time person or a regular casual, you would generally enjoy a protection of at least 3 months before an employer can take steps to try and terminate your employment if you haven't been able to work. The employer also has an obligation generally to make reasonable adjustment in the workplace. So if you can continue to work but perhaps can't do some things or need some assistance or some adjustment or tools in the workplace to make things better, the employer has an obligation to consider that. There are lots of competing demands in the workplace, and the employer has its own operational goals and targets, and has other employees to think about, as well as in some case shareholders, etc. So there are a lot of competing interests, but employees do have rights in that regard, and the employer can't take adverse steps against you just because you've got an injury or illness. There are certain points at time where it gets to the point where the employer has to say, well, at some stage, if this person is not able to do the work for me anymore, is not able to do the inherent things that I hired them to do, then the employer can take steps from there, and can, at that particular point in time, take moves to either alter the workplace situation or end the workplace situation. But if employers are, as soon as you get diagnosed with an illness, taking steps to end your employment, you have rights in that respect. So something to be aware of. Obviously, if the illness is going to stop you working, then that has an impact on your income. As we've heard with some of these treatment modalities that are available, they're very expensive. Some of them are not freely available, or some of them are not supported through PBS, etc. So income is important. In some workplaces, there will be particular schemes in place where you can have access to significant leave. Others in the general population may not have a lot of leave, may be a casual. In those circumstances, you need to look elsewhere for what other sources of income might be available to you. There are, of course, the obvious sort of welfare and Centrelink and those sorts of things. Another source, which people are quite often not aware of, I'm still surprised that people don't know about insurance that's attached to their superannuation fund. So anyone who's working will generally have a superannuation account. Quite often people will have multiple accounts if they've worked for different employers over the years. Some people are very diligent with that and have rolled them all into one, and they'll have a significant body of money sitting there. What is also sitting behind that account is some insurance, and the insurance is there based on your capacity to work. The insurance does differ depending on your particular account, depending on your age, when you joined the account, when your disability arises, etc., and the particular terms of insurance policies, but as a general rule, there is insurance available. It is usually available in circumstances where either you're temporarily unable to work or where you are permanently unable to work. And that's generally commonly known as income protection or total and permanent disablement. So just looking at income protection first, so that is something, a source of income that can kick in when you're unable to work temporarily. So you're totally disabled from working because of an illness or injury, but it's only a temporary thing, so you'll be able to return to work at some stage in the future. Now, not all superannuation accounts will have that insurance attached to it, but quite a few do. Quite a few will have it as an option, so it may not be a default option, but it may be there as an insurance option when you become a member of the super fund. Some of the common definitions around total disability in an income protection sense are usually just about you can't do one of the inherent duties or one of the important duties of your role. So it can actually be quite an easy definition to meet. There are also policies out there that will assist you where you are working part-time hours. So if you've had to reduce your hours because of an illness or because of a need to get treatment, etc., in those circumstances, partial disability policies can exist, which can top up your income in those circumstances. Total and permanent disablement, everyone thinks they know what that means, but it really doesn't mean what it sounds like. Total and permanent disablement, again, is about work capacity. It's not about the extent or chronicity of your injury or illness or life expectancy or anything like that. It's about your capacity to work, and it's particularly about your capacity to work in your usual occupation. Total and permanent disablement doesn't mean never work again. It just means that you can't go back to your normal job or any job for which you're reasonably qualified at the time that you're diagnosed. Now, I've acted for a number of people with melanoma where we've been successful in obtaining total and permanent disablement benefits, but the person has continued to work in other employment or changed career, retrained and gone on to do other things. A classic example is someone who works in an outdoor job, so has had a lot of sun exposure over the years, is diagnosed with melanoma. The doctors say don't work out in the sun anymore, don't go out in the sun. So in that particular job, be it a gardener or a construction worker, those sorts of things, they can no longer do that. So they're totally precluded, permanently precluded from doing that work. Now they may, having worked outdoors for their whole life, not have a lot of other education, training or experience that they can use to get other work at that point in time, but they may be able to retrain and go on to do something else, again, depending on their age and lots of other factors. We ignore that from the point of view of total and permanent disablement. If we can show that that person is totally and permanently disabled and unable to work in their usual outdoor occupation or anything else at the moment that they're reasonably trained for, they can be found to be TPD. And the insurance benefit payable in those circumstances is usually a lump sum amount of money, which that person can then access, help them to retrain and better educate themselves, or help out with treatment, etc. So TPD is a commonly misunderstood term, and one where you need to really look at your particular circumstances. But if you've had to stop doing your normal job, then you should seriously consider looking at the TPD side of things. There are other aspects to TPD definitions, which are the ones that the super fund will first mention to you, which are things like mobility, self-care, feeding, toileting, those very high-level care requirements that most people won't meet, hopefully in their life. So there are very high bars for total and permanent disablement, but the scheme of insurance attached to superannuation also includes the work capacity definitions, which are different, I guess, to what you might think of when you talk about total and permanent disablement. The necessity to have a will is not something brought about by diagnosis of serious illness. Everyone should have a will. Everyone I talk to, I ask them, have they got a will? Whether they're young, old, sick, fit, doesn't matter. Everyone should have a will. It's pretty basic stuff, and it's not brought about just because you're faced with a serious illness. But obviously, having been diagnosed with a serious illness, it's a point in time in your life where you need to think about those sorts of things. They are difficult issues to come to terms with, but it's important that you talk about these things and consider them. Why get a will? The reasons are effectively that a will is the only way in which your wishes can be put into effect in the event that you die. If you leave it up to the law, or you leave it up to a promise made to family members or a discussion that you had with someone else, your wishes aren't going to be put into effect. I can guarantee that. The law where you die without a will is pretty harsh, if I can put it that way, and it just doesn't consider your personal circumstances. It's a one-size-fits-all, and it invariably doesn't fit anyone. You always have to update your will as well, so just having the will itself in place is not enough. Wills can actually be voided by certain life events, so marriage, those sorts of things can actually void your will, and you will need to actually do a new will. So if you have further children, or buy a house, sell a house, get rid of property that's referred to in your will, then you need to update your will to make sure that it reflects your current intent. I've put up there, is writing a note on the fridge enough? Hopefully everyone knows the answer to that is no. There are very specific requirements for completing a will. Now, there are many different ways you can do it. You don't necessarily have to have a lawyer to do it, but that is one option, and in my view, probably the best option. But there are very specific requirements for a will to be enforceable. Anyone can have a will, and they can have a written document that is their will, but the point is it's got to be enforceable. If it's not enforceable, then it's as if you don't have a will. So there are very specific requirements for a will to be enforceable. Now, if you actually don't have a will, as I've said before, you are taken to, or your estate is distributed according to the law. So there are succession laws in every state in Australia. They're all slightly different, but they all have specific rules as to where estate or the residual of your estate will pass. And it may not be to whom you think it might be. If you make a will, there are a couple of minimum people that need to know about it and need to be able to access it. Obviously, your executor needs to know that you've made a will, and you need to tell them about that you've appointed them the executor of your estate. Generally, you should retain a copy of your will, not the original. I think the original should be held either in a bank or a law firm or somewhere safe where it's not going to be destroyed in the event of some catastrophe or fire or those sorts of things. It needs to be held safer, but you need to have a copy of it, and you need to have a copy of it amongst your papers where people will go when they're looking for things about you. So it's important that you keep a copy of that. A quite often complementary thing for wills is an enduring power of attorney. An enduring power of attorney is a power of attorney that kicks in when you can no longer make decisions for yourself. So in circumstances where you're in a coma or don't have the mental capacity to make decisions for yourself, a power of attorney can be a very useful tool and will enable the appointed attorney, the person who can make decisions and do things on your behalf. Quite often, for example, in a family situation, husband-wife, if one of the spouses becomes ill and unable to make decisions for themselves, you would think automatically the other spouse should be able to do things on their behalf. True to a certain extent, but it depends on what sort of decisions we're talking about. If we're talking about dealing with money other than in joint bank accounts or property, larger assets, then that spouse is not going to be able to deal with that or make those decisions without some sort of authority to do that, and an enduring power of attorney is that authority. Powers of attorney can also be made generally, so they can be specific to a particular issue. They can be specific to a particular asset. They can be financial or non-financial. There can be very different. There can be many and very differing versions of powers of attorney. The other topic that I just wanted to touch on was advanced health directives. Now, not everyone is going to need an advanced health directive, but what it is again, a direction from you as to what you want to happen in terms of your health. And it can cover things like treatment or not having treatment. It can cover things like the particular style of treatment you have and who's involved in the decision-making process. It's important, I think, to have that in circumstances where someone who doesn't have a big support network or doesn't have that family support around them. I think it's crucial in those circumstances. I think those with close family and people who know their wishes and where you've been open about what you want to happen in the event that you need treatment and aren't going to be able to direct or guide that treatment. I think in those circumstances you can perhaps get away with it, but bear in mind that doctors can override family decisions, so the family aren't the one that will have the ultimate authority to make decisions about what happens to you in terms of treatment. An advanced health directive overrides that doctor's authority. There are exceptions to that, but effectively your wishes are then put into place and are assured to actually happen. So you can have a formal or informal arrangement. An informal arrangement can be where it's made clear to your family members what your wishes are. Organ donation and all those sorts of things is an issue that can be covered by advanced health directives, but it also can be covered informally and by other means as well. But a formal advanced health directive, again, there is legislation about this, so there is a procedure to follow as to how you put these things into place. And if the procedure is not followed, then it's not valid and it can't be enforced, again, similar to a will situation. Happy to talk more about those topics or answer any particular questions people might have about those issues.
I'd just like to know, do we have to visit any of the, like I'm talking around the wills and the advanced health directives, do they have to be revisited as time goes by or as we change how we feel? Like, things change in our lives.
Absolutely.
So I just want to know, is it current to the end, or do we just come and visit it again and ask to change it? Is that a simple way of doing things? Just ask how we change it?
An advanced health directive is current at the time you make it, but you're right, things do change and people will change their mind. I was in Canberra yesterday talking to some MPA members down there, and we discussed this issue, and a story was told about a patient who, in a fairly critical moment of their care, was asked by the doctor if you stop breathing, do you want me to jump on you and start beating your chest? And the answer at that point in time was no, because things were pretty grim and he wasn't expected to survive. 6 weeks later, things were looking better. And the carer who was there present at that conversation spoke to the patient and said, do you remember that conversation? And he said, no, I don't remember that. What would your answer be now if the doctor asked you that? Jump on me, start beating my chest. So things change, and in those circumstances, you need to change those directions. Again, just like a will, it needs to be something that's kept up to date. If you're in a fluid situation where things are changing all the time, then an advanced health directive, such a formal document, it's difficult to keep that up to date all the time. So in those circumstances, my recommendation would be make sure those around you know exactly what your wishes are and what your directions are, and make sure your doctor knows. So the primary doctor that's looking after your care, be that your GP or the surgeon, oncologist, whoever it is that's primarily driving things, needs to know what your wishes are. There needs to be a conversation about that.
Well, if we can just thank Adam for his time today. I just wanted to reiterate what Adam said. I think it's vitally important that that discussion is had. I think it often can be considered quite difficult to know when to have that discussion. Unfortunately, I have worked as a lawyer in the past, in previous occupations, and have run into a number of people who perhaps haven't wanted to confront that issue, particularly when you're feeling well, and this is even for people who have not been affected at all by melanoma. Just having that discussion can be quite difficult. And I always would encourage people to perhaps consider that discussion now while you have the capacity, you have clear mind, you don't have any pressing issues, and you can really make a clear choice about what you want to have happen on your journey. So whether it's with Turner Freeman or any other organisation or just amongst your family, hopefully from today it just prompts you to open that door and think about those things. But they're not meant to be things that are scared of or taboo. It's simply meant to be a really open and honest, candid discussion. So that way then, when you are in a position where perhaps you can't articulate for yourself, whether it be due to physical incapacity or due to medication and incoherent thinking process, you're not being put in a situation that you would be aghast to see if you had comprehension. And I have seen that happen, and it's a very distressing time for family members, particularly because it can get beyond their control.